Chapter 48. Suits for an Accounting Analysis. Section 926. Origin of the equitable jurisdiction. Historically considered, suits for accounting had their origin in the ancient common law action of account render. This action was so narrow in its operation, so difficult of application, so dilatory and so expensive, that in England it seems not to have been brought more than a dozen times within the last 2 centuries, and in this country, save in the states where it has been developed and perfected by statute, it has long since given place to other and more adequate remedies. This common law action lay only in cases where there was either a privity in deed, as against a bailiff or receiver appointed by the party, or a privity in law, ex provision legis, as against guardians in soccage by the law merchant. Also, the action could be brought by one merchant as such against another merchant as such, charging the defendant as receptor denariorium. This action of account render was the only means which the common law furnished of obtaining a settlement of an account, except that a sumsit might be brought for a determinate balance. But if the balance was disputed, it was necessary for the jury to investigate the items one by one, a task which was practically impossible from the narrow scope and technical rules of this action. The inability of common law courts to obtain a discovery from the defendant on his oath, the difficulty met with in cases of mutual and complicated accounts, and the impossibility of otherwise doing complete justice, it is easy to understand why the action of account render fell into disuse, and a jurisdiction in equity to entertain suits for an accounting grew up. Section 927. Jurisdiction, when exercised, inadequacy of legal remedies. The jurisdiction exists, therefore, and is well established, but the question arises, since there is a similar jurisdiction at law, when may a suit in equity for an accounting be brought? This question, of course, does not arise in those cases where an accounting is decreed as an incident to other equitable relief, nor should it arise where the subject matter is an equitable interest or estate, for here the jurisdiction should be exercised as a necessary consequence, without regard to legal remedies. It is not in every matter of account cognizable at law that the equitable jurisdiction will be exercised, the general rule being that a proper case is presented when the remedies at law are inadequate. Section 928. Plea of stated account. A bar. A plea of stated account obviously constitutes a bar to a suit in equity for an accounting, since in that case the remedy at law is entirely adequate. But of course a stated account may be opened for fraud or error. Section 929. Mutual accounts. The legal remedies are held to be inadequate and a suit in equity for an accounting will lie in cases where there are mutual accounts between the plaintiff and the defendant. Such accounts exist in cases where each of the 2 parties has received and paid on account of the other. Such an account does not exist, however, in a case where one of the parties has merely received and paid out on account of the other, and indeed a mutual account never exists where the account is all on one side. Neither is there a mutual account where there is an account on one side and matters are set off on the other, nor even where there are accounts on both sides which have no connection with each other. Section 930. Complicated accounts. Although courts of equity have refused to entertain jurisdiction of suits for accounting in cases where the items were merely very numerous, they have interposed in many others for the sole reason that the accounts involved were extremely complicated, and even where such accounts were not mutual but were all on one side. It is important then to determine, if possible, what degree of complication will warrant the interposition of equity. The rule became established in England that equity would step in whenever the account was so complicated that a court of law would be incompetent to examine it ad nisi prius with the necessary accuracy, but under the present practice in England, as in New York, matters of account may be referred to officers or referees, so that this rule can now hardly be followed in those jurisdictions. Various tests have been laid down, but the facts of each particular case should govern the court in the exercise of its discretion, and the true principle would seem to be that whenever it is doubtful whether adequate relief could be obtained at law, equity should entertain jurisdiction. Section 931. Fiduciary relations, where a fiduciary relation exists between the parties, and a duty rests upon the defendant to render an account to the plaintiff, equity will entertain jurisdiction of a suit for an accounting. although the account is neither mutual nor complicated. The most common of such cases are those involving trustees, guardians, executors and administrators, partners, agents and co-tenants. Although it is the trust relation involved in such cases which gives jurisdiction to a court of equity, the relation need not be the strictly technical relation of trustee and cestuique trust, a quasi-trust relation being sufficient. Section 932. Same, principal and agent. The principal difficulty is in determining in what cases equity will take jurisdiction of an accounting between principal and agent. The mere relation of principal and agent, without more, the relation not being really fiduciary in its nature, and no obstacle intervening to a recovery at law, is insufficient to enable the principal to maintain the action against his agent. But where the relation is such that a confidence is reposed by the principal in his agent, and the matters for which an accounting is sought are peculiarly within the knowledge of the latter, equity will assume jurisdiction. While the rules are thus settled in favor of a principal, it does not follow that the reverse is true, and that an agent may come into equity for an accounting against his principal, since generally there is no trust or confidence reposed in the latter, and no duty on his part to account. But there are cases where an agent may maintain the action against his principal. Section 933. Same, profit sharers, part owners, tenants in common and joint tenants. The relation between partners necessarily gives rise to the right of an accounting in equity, and persons, although not technically partners, who are to receive a certain share of the profits of an undertaking, may likewise have an accounting. The foregoing rules are applicable, for similar reasons, to part owners and to tenants in common and joint tenants taking more than their share of the rents and profits. At the common law, no action of account for taking rents and profits lay against a joint tenant or tenant in common by another, unless the defendant was constituted bailiff, but this was remedied by statute, and the action could be brought against the defendant as bailiff for recovering more than his share or proportion. This statute has been substantially re-enacted in many of the American states, but the equity jurisdiction exists notwithstanding. Section 934. When a discovery is necessary. The rule is sometimes laid down by text writers and judges, that where accounts are all on one side, but a discovery is necessary, a proper case is presented for equitable interference, but such a rule seems to be only applicable to cases partaking of a fiduciary character, or to cases wherein the accounts are extremely complicated. Section 935. Accounting as incidental to other relief. The remedy of accounting is in most instances a necessary incident and part of the relief granted in suits brought by those beneficially interested, against trustees, either express or implied, and persons standing in fiduciary relations, such as administrators, executors, guardians, directors, and the like. The equitable jurisdiction is also practically exclusive in proceedings for an account and settlement of partnership affairs, including suits for an accounting and settlement of the firm affairs between the co-partners themselves, suits for a settlement of the firm affairs between the survivors and the executors or administrators of the deceased, when a partner has died, and suits to settle the affairs of an insolvent firm, and to adjust the demands of the firm creditors and the creditors of the individual partners. The equitable jurisdiction over partnerships is a necessary outgrowth of the jurisdiction over accounting, and the remedies of dissolution, injunction, and receivership are incidents necessary to a final and complete relief,